All right, welcome back to the Law&Crime Network. My name is Bob Bianchi. We're in the Wilbourn case. There has been a major news today. Defense expert in the penalty phase excluded, thrown out by the judge. And just now, we listened to the defendant, Wilbourn, stand up and speak to the judge and say, no mas, my lawyers are no good. I'm not getting a proper defense. I don't want to present any more mitigating factors. And this Judge Coffey, well, this Judge Coffey is the real deal. Harvard-educated lawyer, a state prosecutor, defense attorney, public defender, may I add, worked for the DOJ as an assistant United States attorney. This judge is the real deal. He knows his stuff. But you know what? Before we break this all down with my great guest, Gene Rossi, we got another judge that you may find, or when you hear the name familiar, Judge Brandon Birmingham. He is the presiding judge of criminal part in Dallas County. Sound familiar? You remember the famous case of Texas versus Roy Oliver, the police officer convicted? Well, Judge Birmingham is the judge who presided over that trial, and we know he's the real deal as well. I have so many credentials for him, including his podcast, A Murderous Design, that looks at circumstantial evidence and how it puts cases together. But I love most of all the things, Judge, you got it, and we don't have a lot of time because it's got breaking news. I love on your bench, on facing you, that the public can't see, you got a quote. I really respect this. Be humble. The bench does not belong to you. It belongs to the people. Judge, welcome to the show.
Well, it's a pleasure to be here. I'm surprised you guys done your research. Not many people know about that quote.
Well, you know, I know that. I know about how you've done some great stuff with high-risk domestic violence court for both the abuser and the abused, the AIM program for nonviolent 18 to 24-year-olds, as well as the bail reform, which we just did here in Jersey, as far as not being money-oriented, but rather risk factors. So I know you're a progressive, and you're taking care of both sides of the equation, effective criminal justice, but also fairness, compassion, and mercy as well.
Yes, sir. Well, I appreciate those kind words. It's a good job. I've really enjoyed it. I enjoy all the things you talked about, and I got to tell you, I really enjoy a good trial like this, like we've been watching unfold over in Memphis the last couple of days.
Okay, well, before we get to the clip of what just occurred in court, Judge, I want to ask you because, you know, I've never been a judge. I've been an advocate as a prosecutor. I've been an advocate as a defense lawyer. But your position is much more unique. You're the one that has to make the ultimate calls on these decisions. And we just heard the judge basically exclude an expert earlier today. These are tough calls that you make. But in a death penalty case, Your Honor, do you think precluding a judge on a theory that is not scientifically reliable is going to come back to haunt them in terms of not being able to present mitigating information that may have been relevant in the death phase?
That risk, but I will say that you know, in trying cases when I was a prosecutor, the 4 death penalty cases I was involved in, you know, you always tend to err on the side of letting stuff in. However, the law is pretty clear, and if you're not talking about something that's either scientifically reliable or otherwise passes the test under 702 and 705, or the expert rules here, that's what they are here in Texas, well, then the law doesn't allow you to get into them. I understand that you know, the expert was going to talk about you know, racial trauma, and that certainly could be a real thing. It's just that there's not a lot of scientific literature out there to back it up. It seems to me, too, that the expert hadn't gotten everything that he needed to know about this particular case. I mean, I understand he didn't even know that the officer, you know, there were some facts that he didn't know that really could have hurt him. So maybe it's a blessing in disguise. You know, there's other ways to get about what was going on in his mind, and in particular, that's to testify. So perhaps this is a ruling. You know, I was thinking maybe when I first found out about it, this was a ruling that might steer him to actually testify, Mr. Wilbourn, to talk about what was going on in his mind and those things. The expert couldn't do it. It could come from him. So we'll see what we go from here. And then we had all the stuff that happened just recently.
Right. So I agree with you, Judge. He could still present his defense about how he felt. He can get on that witness stand. That expert was rightfully precluded by the court. But then, Judge, another bombshell drops right after that. That's Wilbourn in court saying to the judge, basically, I just want this to end. Go to the sentencing. Let's have the jury deliberate. I don't want to present any mitigating factors. My judges are no good. Let's take a look at that clip. Okay, welcome back to Law&Crime Network. So that's the pastor, Ralph White, who's testifying as a mitigation expert in the penalty phase of Tremaine Wilbourn. I have Jennifer Schuster with me now, in addition to Judge Brandon Birmingham. Unfortunately, my man Gene Rossi had a go off air. How Jennifer's an Avo client's best Schuster law firm out of Chicago, all areas of family law, experienced complex litigation, certified mediator, group leader at Rainbow Resolution, which is such a great program for support for kids whose parents are going through divorce. And I didn't know this, Jennifer, that you were a reporter and were the first to interview Stephen Avery of the Making a Murderer fame after he had been charged. We got numerous jailhouse interviews from him and actually became a witness during the course of that criminal case. Welcome, Jennifer.
Thanks for having me, Bob. Yeah, that's right. I interviewed Stephen Avery 2 times and actually had a brief appearance in Making a Murderer Part 2 along with your colleague Aaron Keller.
Oh, my God, the great Aaron. Okay, listen, Judge, we got so much to cover in a short period of time. He decided to go forward with the mitigation evidence. Obviously, this is a good mitigation witness, but I'm just curious as a judge. The judge basically said to him, if you don't do the mitigation evidence, because he indicated he just wanted to go right to the sentencing and have the jury deliberate, he didn't like his lawyers, didn't want to put any more witnesses on, would you have ever considered compelling the defense to go forward with mitigation witnesses irrespective of the client's desire?
I think that's a pretty big stretch to disregard the client's desire. In other words, there are probably things that I wouldn't know about their case. That there may be a really good reason why they don't want to go forward. Now, it's also possible the reason why he didn't want to go forward is just to try to inject error into the trial, thinking that that might preserve him later on appeal. But I mean, at the time, all you can do as the court is give them the warning, give them the most dire warning you can, tell them the worst case scenario that this can do, and make sure that if that's the path that they choose to do that knowingly and intelligently, knowing all the risks and all the circumstances that may come with that type of decision.
Right, I agreed. And Jennifer, well, he made the decision, ultimately put the witnesses on. The first one is this pastor. Pastor makes a great appearance, talks about the difficulties in the neighborhood, that he knew him from the defendant, Wilbourn, from before, because he was in his program, that eventually Wilbourn reached out to him because the pastor had asked. He kind of humanizing the defendant a little bit. They met, and then he was willing to turn himself in. I mean, listen. That's good mitigation information in my mind. May not win the day, but it's a good witness for them, no?
Right, absolutely. I think that this is going to be his best argument moving forward, that he had a deprived childhood, but there are folks like this pastor who can testify to the fact that he has some redeeming qualities. I mean, after that expert being disqualified, only he can probably get on the stand and testify to the fact that he had this panic, this race-based panic. But at this point, I think these witnesses like the pastor are most valuable in him trying to escape the death penalty here.
Yeah, I mean, having tried death penalty cases as a prosecutor, you always worry about witnesses like this because there's a lot of humanness that comes out with this witness, and obviously all you need is one juror to not want to go forward with that penalty. Judge, what are your thoughts about how the pastor's doing?
I think he's doing really well. You know, jurors have to know about the background of the defendant. You know, the day of the killing is put under the microscope, and it's probably the most well-documented day in that defendant's life. But the jurors need to know, they intuitively want to know about where the guy came from, what was his life like. And so you've got a pastor who, my goodness, arranged for him to turn himself in. I mean, those are major points for the defense. You've got on the other side, though, you're going to see in the cross-examination, I'm sure, from the prosecutor, this what you normally see in cases like this, where you'll have the arguments that not everybody who was in that neighborhood turned out to be a police officer murderer. Not everybody in the neighborhood went down the path that Mr. Wilbourn went down. You know, so you're going to have these arguments. The more in the background that you get, the further into the defendant's life that you get, which is good for the defense, but it also presents some really good opportunities for the prosecutors to bring up some good points. Those people that did make it out, those opportunities in the defendant's life where he could have chosen a better path, those opportunities to take the advice of a guy like Pastor White, who by everything we know is a very involved communitarian, but he chose not to avail himself to a guy like Pastor White. And so these are squandered opportunities.
You know, that's a great point, Judge. And Jennifer, you know, one of the things that I said when I was prosecutor, I would ask the defense lawyers, bring me the mitigation information about your client. I know it kind of consistent with what the judge is saying. You open up a file and you see all bad guy stuff, all bad girl stuff. And we all know that not all people are not all bad or all good. So give me something that I can make a reasonable plea offer. Don't come to me after the plea or come to me after the sentencing, which was happening routinely after a judge has given a state prison sentence, and tell me what the guy's background or history is like. I think it's really important, and you're a certified mediator, and you do this in family all the time. It's important to bring life to the prosecutors and to the judge and to the jury right from the outset when decisions are being made. What do you think?
Yeah, I think that's absolutely right. I mean, the jurors are going to be looking at this guy now from an entirely different perspective. I mean, is his life at all worth saving? Is there any redeeming value at all? And I think that's a much more difficult choice for jurors to make instead of sending him to life without prison. I mean, we know that frequently jurors will say that they think they can impose the death penalty, but when it comes down to it, when they're actually in the situation, it's very real and very different. And as we know in Tennessee, they just need one juror to say that he or she doesn't want this man being sentenced to death.
Well, people ask what it is that defense lawyers do, and this is what they do. They put the humanizing witness on like the pastor. The defendant made a good decision to allow mitigating information because, as you say, Jennifer, and Judge, I know you know, it only takes one to say, I just can't do the death penalty here, and that's the end of the story. This has been a compelling, amazing day with the exclusion of one of the death penalty witnesses for the defense by Judge Coffey. This guy is the real deal, just like Judge Birmingham is. They know what they are doing and how to handle a courtroom, and now the defendant has decided that he's going to allow the mitigation phase to go forward. We're going to go to a break. We'll come back on the other end with our great guest. Stay tuned. Okay, welcome back. So what you saw there was the Pastor White, who was testifying on behalf of the defendant, Wilbourn, on the penalty phase of this case. And Judge, as we were talking about before, Judge Birmingham from the infamous Roy Oliver case and others as well, you are the PJ in criminal. So you're the presiding judge. All your judges elected you to that position, and there's a picture of you right now in your robes. Very impressive work.
I always forget how bald I am.
You wish what?
I always forget how bald I am.
Well, I'm glad they don't have a camera on the back of my head. So in any event, this pastor's we talked about, the prosecution didn't really hurt him too bad. Seems like a nice guy. I'm not even sure whether or not I would have been asking any questions. What are your thoughts?
Well, you get a witness like that. He's very likable. I noticed I kind of laughed out loud when he said, you know, his wife looked at him and knew he was going to do something crazy because, you know, that's what kind of a heart that he has. You can't beat up on a guy like that. What you can do if you're the prosecutor is just kind of fish around, maybe just a little bit. And that's kind of what he did. Stick and move, see if there's anything in there. Maybe the defendant made some statements initially that the prosecutor could have gotten out. Maybe, you know, there was some actions in turning himself in that the defendant made that would have helped the state on that. I thought it was, you know, overall a good witness for the defense. He talked about the deterioration of morals and values in that neighborhood. I can promise you that's probably going to be a quote we're going to hear in the closing arguments. Yeah,
I'm not sure that quote's going to be coming from the defense attorney, or I'd be taking it as the prosecutor. You know, he just gave you
right.
he just gave you in a nutshell who the defendant is in my mind by saying that. But Judge, I got to ask you one last question before I get to Jennifer. We have been debating on the Law&Crime Network, covering a lot of trials in Texas. There's this thing about the victims' pictures being put in the courtroom in certain trials by the witness stand, which to us Jersey guys, we're the East Coast, New York people, Pennsylvania, Virginia, we talked about, would absolutely be improper victim impact. Not even evidence. It's not even really evidence in the case. Can you explain, has that been vetted through the Supreme Court of Texas as well as the United States Supreme Court?
Well, the rule is that once a picture is introduced in one part of the trial, it can always be introduced or played or showed at another part of the trial. And so the way that I do it in practice and have been doing it for years when I was a prosecutor is that if it was my witness or if it was my case or my argument, then I could display it. And as soon as I was done with my witness, I could take it down. And, you know, you're tempered by, you don't want to seem sappy as the prosecutor. You don't want to seem like you're really trying to play on the emotions. But on the other hand, you do want to make sure that the victim is a part of the trial. As the prosecutor, you are constantly fighting against that battle that the victim is somehow lost in this whole process, but we wouldn't be here without it. So it's really up to the court's discretion. Once a picture is properly admitted, it can be displayed at all times during the trial.
Yeah, Judge, though, in the Christopher Love case, and I agree with you, if you have a relevant photo, this was a photo of her in her pediatric jacket, whatever they found the relevance to that was, it wasn't a crime scene photo. It was clearly a victim impact picture. I'm not even sure if it was admitted, but let's assume that it was. In the Christopher Love trial, the two pictures hung there throughout the entire trial. Every witness, openings, closings, summations, jury deliberations. Is that still within the discretion of the court down there in Texas?
Yeah, it is, and it's up to each judge. Yeah, I've been in some courts where once one witness is up and the pictures are introduced, then you've got to make another showing that the picture is somehow relevant with the next witness, and there's things like that. The defense has got to object to it. The state has to use their best judgment in making sure that we do that. Now, I'm sure that everywhere you've got to have a living picture. We do have to prove in Texas, as I'm sure you do everywhere, that the victim of the murder case was at one point a living, breathing human being, an individual born alive, and there's really only at least one way to do that, and that is to show a living picture. So that living picture makes an appearance all the time.
I've done murder cases my entire career as a baby prosecutor, defense lawyer, and the head county prosecutor. I have never seen anyone need to prove that the victim was alive in a case, but it's a good point. And look, everybody does it differently. Our death penalty, we were kind of amazed in that case. Jennifer, just to get to you real quick, in the Love case, for example, the judge took the verdict in like 30 seconds. There wasn't polling of the jury. Or in Jersey, this would be like a long, protracted, process. And in fact, I've had murder cases as a prosecutor where during the polling of the jury, a juror changes their mind.
Right. I remember that in the Love case. It was just so shocking how quickly it was read. And then it was like, okay, let's break for the weekend. Everybody back here on Monday for the sentencing phase. It was pretty startling, but I guess that's how they do things in Texas. The judge can speak to that.
Yeah, I mean, Judge, I don't want to put you on the spot with that. I'm sure you guys, know what you're doing down there, of course. And great. It just was really strikingly odd to us and probably if you came up here and saw when we used to have a death penalty, how clunky and difficult it was to get a death penalty conviction, you'd be in shock about how we do it here. Jennifer, real quick, in 15 seconds or less, does this pastor do a good job for the defense, as the judge indicates?
Absolutely. He's an authority figure in the community. He spoke to the fact that this defendant had a deprived childhood, and he showed that he has at least some sort of redeeming quality in the sense that he went in with this pastor to turn himself in.
Right. Well, listen, we are in the Wilbourn case, and if you folks aren't watching it, if you're not in that chat room, you are missing out. I got two great guests, but we have had bombshell developments that have occurred here today. Exclusion of witnesses for the defense, motions to preclude mitigation. We'll be back on the other end of the break. Okay, welcome back. So, Judge Jennifer, let me throw to you first. Judge, we've watched this testimony a couple times. This is the first witness for the mitigation phase for the defendant, the pastor. We all agreed he did a good job. He brought some themes out that I thought were important to humanize. We talked about it a little bit, that he'd go to counseling, group sessions, basketball, to the church. I mean, he brings a little humanity to the guy. But I want to ask you specifically, because we never get an opportunity to have a great, seasoned judge like yourself, or we don't often. Bones from our chat room talks about also not only what a great judge Judge Coffey is, but he has a great rapport with the defendant. And what are your thoughts in terms of judicial temperament? I mean, I've seen some judges who have been outright nasty to litigants, nasty to defendants. It's brittle, intense. The judge is clear, he's direct, and I think I know what your answer is going to be, especially with that "be humble" quote behind your bench. But what are your thoughts about that?
Well, I think fundamentally everybody wants an opportunity to be heard, and the worst types of atmospheres that the worst atmosphere that you can possibly create in a courtroom is one of oppression, where one side gets to be heard and the other one doesn't. Or if the defendant has questions, I always give them an opportunity to be heard, and I always tell them, I promise you I won't make any major decisions until I hear from you, and then we'll talk about whatever it is that you want to talk about. That helps create an atmosphere that is better for everybody involved. The jurors, the lawyers, the victim's family, the defendant, the lawyers have an opportunity to work better in that atmosphere. So you've got to fundamentally, people want at least an opportunity to be heard. They don't always expect you to be right and vote in the way that they want you to, but they do at least want to be heard. And so, the colloquy that we saw with the defendant, Mr. Wilbourn, in this case about, he didn't want to present mitigating evidence and things like that. He had an opportunity to talk with Judge Coffey, and Judge Coffey, of course, very appropriately steered him in the right direction, reminding him of everybody's role. He, as the judge, can't make the state make a plea bargain offer. He can't make the state do this or that. And so he gave Mr. Wilbourn an opportunity to be heard. And ultimately, I think it probably helped him in the trial because he did put on some mitigating evidence.
Well, Judge, that's a great answer. And nobody knows about temperament and how to negotiate and mediate than a family law attorney. Unfortunately, Jennifer, I wanted to be able to get to you, but I'm being told we got to go to a break. But hopefully on the other end, I'd like to get your thoughts on that. Let's go to break. We'll be back on the other end. Welcome back. Okay, we're doing the Wilbourn trial. It has been an amazing day, and we genuinely and gratefully appreciate Judge Brandon Birmingham, the Dallas County, Texas presiding judge. You can find him at Judge Birmingham on Twitter. He was on the Roy Oliver case, and he has done so many great innovative things in the state of Texas. The next time I'm down there, I'd like to actually meet up with you, Judge, and have a cup of coffee, and I know you got to go back to court.
Today, Ms. Schuster, it was good to talk to you and hear from you as well.
Thank you, Your Honor. Have a great day. Blessings.